Welcome to our second lecture covering the topic of religious discrimination in employment. I'm going to advance to where we were when we were last together, the end of lecture 1, and we will begin at that point. As always, I recommend that you look at the PowerPoints or the study guide to help you follow along with what I say. If the term is in italics, that's an indication that, at least for my purposes, I thought it was important enough to remind me about. I hope that you will also make note of that. I think that will be a good tool for you to prepare for tests. So let's begin. Again, we're talking about what qualifies as reasonable accommodation of religion in the employment context. Up to this point, we've talked about, well, what is religion? And also kind of what are generally the two categories of protection that we have under the religious discrimination protection of Title VII. One is protection against religious discrimination, the same type of discrimination that a person might have because of their race, their national origin, or their gender. And then we talked about, in kind of brief terms, the second part of that equation, which is when the employer may not have any bigotry against a particular religion, but perhaps isn't accommodating the observance of that religion. And that has to do with reasonable accommodation. And so that's what we're really going to focus on to a much greater extent. We've touched on it a little bit in lecture 1, but now we're going to do a deep dive into the topic. And whenever we talk about reasonable accommodation in the context of religious discrimination, we have to balance that against the fact that the employer is not required to engage in an accommodation that would cause an undue hardship. So we'll see those terms almost always fit together. The employer has to engage in a reasonable accommodation up to the point that it becomes an undue hardship. So let's get started. Again, here we are. We've covered the first 3 topics, and now we're going to talk about the duty to reasonably accommodate. So, employees have the duty to inform the employer that they need some type of accommodation. The employer doesn't have some obligation to be an expert about an employee's religion or to understand the obligations of that religion. The employer doesn't have any obligation to look at the schedule and say, wow, this employee is always missing work on Saturdays. It must be because of a religious reason. Or, boy, this employee seems to be not satisfying the requirements of the dress code. It must be because of a religious reason. Now, the onus is on the employee to identify the problem and to bring it to the attention of the employer. And if the employee fails to do that, then the employer has no duty to accommodate. The next thing I guess that's important to remember is that sometimes these issues come up well after an employment relationship begins. After all, the employee might convert from one religion to another, or even if he or she is in the same religion, he or she may have become more devout and therefore be following the requirements of the religion more specifically. The fact that a person's level of commitment or even their religion has changed isn't necessarily evidence that there's a lack of sincerity given the new change. Sometimes what happens is that an employee won't share their religious situation at the interview stage. The employee may decline to do so because of concerns about discrimination. And so it may be that shortly after the employment begins that the employee says, oh, and by the way, I'm not going to be able to satisfy this aspect of the dress code. Oh, and by the way, I'm not going to be able to work on these particular dates. There could be some issue, honestly, about the honesty of the employee during the application process, but because the employer would have been required to reasonably accommodate those parameters even at the time of the interview, I would recommend that an employer not take adverse action because of perhaps a lack of candor on the part of the employee, and to go ahead and treat this new information as if it is sincere unless there's some other reason to doubt that. An employee is entitled to bring up these issues long after the hire. Now let's imagine though that that an employee or an applicant comes to you, is applying for a job, and you say, well, we really need help for the Friday evening shift, and the employee or the applicant says, oh, well, I happen to be a member of a religious group and because of my religion, I am not able to work on Friday nights. If that's, of course, the entirety of the job, well, then that would obviously disqualify the person. But let's say it was just a portion of the job. Let's say you were hiring somebody for full-time employment, and one of the aspects of the job is Friday night work. Under those circumstances, an employer can't just say, oh, I'm sorry, we were hiring and the 40-hour week was going to include Friday nights. And so therefore your inability to work that during that time, though perfectly understandable, disqualifies you from consideration. That is not how the law works. The employer is still going to need to reasonably accommodate that employee despite the fact that there's going to need to be some shifting of schedules around. And so it's important when you're confronted with those types of issues to make sure that when you're choosing the successful candidate, you don't give weight to the fact that one of the candidates you're going to have to reasonably accommodate. That's a tricky issue. And when you confront such situations, I encourage you to talk with a more experienced HR professional if you don't have a lot of depth in this particular area, or perhaps more likely or more appropriately to talk with an attorney to make sure that you can defend the position that you take if you're electing not to hire that person particularly. So once the employee does let the employer know that there's some kind of conflict, or it could be the applicant's situation, then it's important that the employer acts quickly. So let's say the employee says on, Thursday afternoon, oh, by the way, I can't work Friday nights because of my religion. Well, the employer can't say, okay, well, in the next few weeks we'll worry about that. Well, if the employee is scheduled to work the next day, then really the employer kind of needs to launch into the activity immediately and trying to figure out a solution. Now, certainly the employee should have given more notice, and it may not be possible to resolve it before this next Friday, but I certainly wouldn't dismiss an employee who lets you know about it and you can't solve the problem before that next day. But the bottom line is you can't just kind of say, oh, well, we're busy right now, I'm not going to worry about your accommodation issue. It is something that needs to be addressed quickly, and the employer has an obligation to do a back and forth process to explore possible solutions. This might be an understanding, and you shouldn't quiz the employee about the specifics of his or her religious beliefs, but the specifics of his or her religious obligations can be. For example, the employee might initially say, well, I need to be off work by 6 because of my religious obligations. Well, it might be that that is a set time throughout the year. Or it might be that at certain times of the year it's earlier, or certain times of the year it's later, depending upon when the sun sets. So there can be some issues like that. So you may want to get a little bit more granular. Okay, so you're saying you need off by 6. Is that, every Friday or every whatever day of the week it is? And to get as much specificity as possible. So that you can know exactly what the requirements are, and also what the particular limitations are on that person. What can and cannot they do? For example, perhaps they can't be at work, but perhaps they can be on call to answer questions. Maybe that's permitted, maybe it's not. So getting the full scope of what the limitations are, and then discussing ways of approaching it. And it's a good idea to get the employee's thoughts. What does the employee think would be a good solution? We'll talk more about balancing what the employee wants versus what the employer wants, but it's almost always a good idea, in fact I would say it's always a good idea, to find out what the employee would like and to allow the employee to kind of explore lots of different issues. So don't say, well, what's your first choice? Just say, what are some choices that would work for you? And have the employee kind of list various things. And then the employer can say, well, how about this option? And then when the employee perhaps might say, well, that's not going to work, say, well, how will it not work? And if the employee says, well, it won't work because I don't like it, because that's going to interfere with my social plans on Thursday nights, well, then you can say, okay, so the problem isn't your religion at this point. Your problem is some other factor. And then, of course, the employer isn't required to accommodate those other aspects. So it's just the religion that the employer is required to accommodate. We already talked about this earlier, but just keep in mind that the duty to reasonably accommodate applies to religious practices, not beliefs. And so the employer has to accommodate the religious practices. And these are the common categories that we see come up. One would be religious or worship rituals. These might be prayer rituals or customs along those lines that the employee may need to do throughout the course of the day. Another would be proselytizing or evangelizing or trying to convert people at work. The employee may feel a religious obligation to try to persuade other individuals to either become more devout or to share his or her religion. There may be requirements about attire and grooming. Many times attire requirements might have to do with personal modesty or perhaps the wearing of distinctive apparel associated with a religion. Grooming can relate to things like hair length, beards, things along those lines. So those are areas to consider. And then there can be issues about diversity policies and things along those lines. For example, an organization might have a diversity policy that presents gay and lesbian circumstances in a certain light that the a religious person might find inconsistent with his or her religious beliefs. And so there can be some challenges along those lines. For example, the employee may not want to attend a diversity training session that talks about those circumstances, those life circumstances that some employees might be experiencing in a way that is inconsistent with the employee's belief system. So there can be challenges in navigating those types of issues as well. The right to be free of religious discrimination is not absolute, and certainly the duty to reasonably accommodate is not absolute, because again we have that undue hardship requirement. For example, with respect to the proselytizing, we'll see this in more detail later on, but if you had an employee who believed that he or she had to proselytize 8 hours a day during the workday, well, how would he or she ever get work done? The other people that he or she works with would be likely their productivity would diminish and their ability to get their work done would be diminished, and also they would not like it. So certainly there are limits to the reasonable accommodation duty. I said this before, but it's really important to be creative about how you're going to go about solving this, and that is very helpful to get the employee's input. In some cases, the employee may be part of a religious community that has gone through these same types of issues before, and so the employee oftentimes will have creative solutions that might not have occurred to somebody who wasn't part of that faith community. Now, just because that's what the employee would like to do doesn't mean the employer has to do it, but it's important to listen. That's part of that good faith obligation. An employer who doesn't even ask for the employee's solutions is not setting himself up or herself up for success. Simply asking is good evidence to present to the jury in the event that a reasonable accommodation can't be reached. And there's kind of no harm in it, right? I mean, you're definitely not putting yourself at a disadvantage. And so for that good faith the good faith evidence that you've asked is very helpful when you ultimately can't reach a conclusion or a solution. Sometimes you won't be able to. What is going to satisfy the employee isn't going to be workable for the business. At least the employee may not think about it being workable. So it may be that the employee is being unreasonable, or it could be that the religion just doesn't mesh well with this particular job environment. And so when you encounter those situations, it's especially important that you document that you've asked these questions, that you've tried to be creative, that you've brainstormed about lots of different paths. So what are the factors that should be considered in deciding whether the accommodation is reasonable? Well, first of all, did the employer come up with some suggestions? The suggestions, and of course, these should be documented, so you can say, yes, I gave Bob, the employee, the suggestion of X on this particular date, and Bob said that wouldn't work, or whatever. That's an important piece of evidence. It's a good idea to document that it was communicated to Bob on the date that it was communicated, maybe who was present, maybe what was Bob's answer with respect to that. Another useful piece of the puzzle to figure out what's reasonable is the size of the employer's workforce. If the employee does a unique job that no one else in the staff does, and the employee suddenly needs to have off, every weekend or every Saturday or Sunday, and the nature of the work is such that things can go wrong, or there may need to be an employee on staff to do that, well, that starts looking to be undue hardship at that point. On the other hand, if there's 50 different employees, any one of whom could do that particular job for that particular Saturday or Sunday, it becomes much more reasonable. The employer ought to be willing to check with other employees to see if they're willing to swap schedules or swap job duties. Sometimes the employee is going to be unable or unwilling to do that because if it's a sinful behavior for him or her to engage in, he or she may consider it sinful to ask another employee to commit that sin. And so sometimes the employer has to be the one to make the request of the employees. That's almost always going to be a reasonable accommodation to have the employer check with the employees. Then we want to look at what's the financial cost of the accommodation. If it's simply sending out an email to employees or collecting that data, that's going to be a de minimis or just an administrative cost. If it involves, hiring somebody from the outside, and that pay would be extra pay, or something along those lines where you can actually see a dollars and cents increase to the cost of the business, that's much more likely to be in the category of undue hardship. Now, let me distinguish this from the duty to reasonably accommodate a disability. And under that standard, routinely employers are going to have to spend some money, sometimes thousands of dollars of money. But that's a very different standard than what we see with religious accommodation. Usually for religious accommodation, there is no need to spend money. So financial cost is a significant factor. Here are some examples of approaches to consider. Voluntary swaps this should be among, I apologize, among employees, so that other individuals can take over those shifts. Unfortunately, many times the shifts that the religiously observant individuals want to avoid because of their religious obligations are also times that non-religious employees want time off as well. For example, if the Sabbath observer, say the Seventh-day Adventist or the Jewish individual, wants Friday night and Saturday off, well, lots of non-Jews and non-Seventh-day Adventists want those days off. If you happen to have a Christian employee who wants Sundays off, well, lots of non-observant individuals also want Sundays off. And so many times, even though the employer agrees to allow these voluntary swaps, many times it's very difficult for that religiously observant person to find enough employees who are willing to make the swaps. An employer probably isn't required to allow or to pay for overtime for an employee who is going to be working over 40 hours. And so under those circumstances, an employer could say, well, we are not going to be able to get into overtime if the person is now suddenly going to be working a Sunday, then we're going to take away another shift. And so sometimes the religious employee initially meets with some success and is able to persuade employees for a while, his coworkers for a while, to accept the swaps. But as time passes, there may be less enthusiasm for the swaps. Also, sometimes the workload varies, and maybe during certain parts of the year, there is less of a need for weekend shifts, but maybe as the employer is getting closer to a significant work crunch time for the organization, there needs to be more hands on deck over weekends, and therefore it may cease to be possible to get enough people who aren't already scheduled for those days to come in to work those extra shifts. So there can be challenges along those lines for the employee who is religiously observant. Another option, and this works particularly with industries that there isn't the need to have somebody there for set times, and that would be to have a flexible working schedule. For example, let's say that the ordinary work day for this workforce is 9 to 6. You happen to have, say, an observant Jewish person. Sunset at this time of year is at 6 o'clock. He or she needs to leave work, get home, get ready to go to temple, and so he or she might need to leave by 4:30 or 5 on Fridays. Well, perhaps they can work through lunch, or maybe they can stay a little bit later on Thursday or arrive a little earlier on Friday morning. If it's possible to still get the work done with an altered schedule, that can be a good solution. Sometimes it's possible for the employees to use some kind of vacation or PTO for these times. Now, an every week occurrence probably isn't going to work, although even there you could say if the employee just has to leave an hour early, 52 weeks times 1 hour is only, 6.5 days, and so they could just use 6.5 days of their vacation time. That could be one way. If it were tied to maybe a once a year or twice a year significant holiday time, perhaps the employee needs to take off Rosh Hashanah or some holiday associated with the religious observance that isn't weekly, then the individual can take off those days. Some employers like to use floating holidays. Instead of having Christmas off or Memorial Day off or 2 days at Thanksgiving off, perhaps they instead say, this is how many holidays you get off. You can pick the ones that you want. And so that person who needs to take off a less common holiday is now able to maybe work on the Friday after Thanksgiving or on the other day that is not a holiday that he or she participates in, and reserve those days for the holidays that are important for him or her. By the way, the term holiday itself is, as you probably know, an abbreviation of the word holy day. And some Jehovah's Witnesses won't use the term holy day or holiday because of the fact that they do not participate in that kind of idea. And so one example, I've seen this in my professional life when I was working for a retailer, was that some Jehovah's Witnesses wouldn't say Happy Holidays, or would not also be willing to say Merry Christmas, because those terms were not terms that they felt were appropriate. And so what we would sometimes do is say, Happy December, or Happy December 25th, or, you could brainstorm with them some way of describing it that would not violate their conscience, but still convey the idea that they are being gracious to their customers. And so again, this would be an opportunity to be having that interactive process, because there probably are some Jehovah's Witnesses that feel perfectly fine saying Happy Holidays. And so you'd want to make sure that you understand that person's particular perspective on these issues. Sometimes you can shift a person to another department where it's not necessary to have people work during that time. Sometimes you can alter or switch out job duties. Usually in these situations, you hope not to take away income from the individual. But if there aren't jobs that are at that same level that the person's qualified to perform, and you can't figure out a way to keep them in that same job and get the job duties done, then certainly it's better to offer a job at a lower pay or a job for fewer hours than terminating the person. And so as a less good option, but still one to consider if everything else doesn't work out, some kind of lesser responsibility. But you want to save that for after you've really thoroughly explored the other options. And if you do have to take away hours or reduce the pay, you want to have very well documented that you really, really tried to not go down that road. You might be able to reschedule certain events. If you're having an important sales meeting on a particular date and it's really essential that you have Bob there, and hopefully you know well in advance what Bob's significant dates are for his religious observance, then you might be able to move that date to something that would work better. We've talked before about dress codes, and I said at the time that in the area of sex, it's perfectly okay for an employer to have differing standards for men versus women. There's relatively little that the courts are going to require of an employer that is going to be considered discriminatory with respect to a dress code. And that's true in the areas of religion as well. But when an employee is presenting a religious concern, then the employer should listen and should consider whether there can be some flexibility. For example, let's say the employees in your organization wear t-shirts to identify them as members of the staff. Okay, that's fine, but maybe the t-shirts are short-sleeved. Well, and let's say a particular employee, his or her religion requires a heightened level of modesty. Well, then you might allow the employee to wear a long-sleeve shirt underneath the t-shirt. Let's say the usual clothes that are worn are a polo shirt that has an open collar. Well, maybe the employee might be permitted to wear a t-shirt underneath that makes it a little bit more modest. Those types of things can satisfy that. So it's good to brainstorm with the employee about how there can be some compromise between what the dress code is and what the employee's requirements are. Sometimes these types of issues do raise safety concerns. Imagine for a second that the employee wants to wear a loose-fitting garment that perhaps tends to more conceal the shape of the body. Well, that can pose safety hazards. If this person is working with machinery, the loose sleeves or loose clothing could get caught in the machine and the person could be seriously injured. Usually safety issues are going to trump religious issues. So usually the employer is going to be able to enforce dress code constraints that have to do with safety. Now, what the solution might be to that would be to move that employee to a different part of the workforce or in a different area in the work unit. Grooming standards oftentimes relate to hair length and to beards. And so those can be considered with respect to that. And again, usually the employer is going to need to accommodate those beliefs unless there are safety issues. For example, and we'll talk about the turban cases in a bit, but with respect to beards, many of the gas masks, for instance, the firefighters wear, can't get a good seal if the man has facial hair. And obviously, if you don't have a good seal in a gas mask, it means that whatever is in the air is getting under the mask and might be causing the firefighter to become ill. And so if there are safety implications that require a clean-shaven face, then the courts are likely to say safety is going to trump the religious observance. And we'll talk about the turban cases in a couple of minutes. Let's go through a few scenarios. Before we get started on these, I have lots of both reasonable accommodation and undue hardship scenarios. I have so many because these cases are very fact specific, and we can talk in generalities all day, but I think it's really helpful for us to drill down with lots of examples so you get a feel for what courts have actually done in this area. And so, talking theoretically about, well, that we need to reasonably accommodate until it becomes an undue hardship, where those lines are until you get into specifics is pretty darn vague. So please focus on these examples. In fact, I would encourage you independently to go through these examples several times, maybe cover up the last sentence and start working on predicting to see if you are on board with where the line is drawn in these cases and whether you'd be able to predict what the court would do. So let's consider our first scenario. We have Mary, who is of the Jewish faith. She's a baker, and when she's hired, she tells the bakery that she can't work on Friday night because of her religious obligations. The manager replies that she is the only Jewish baker and all the other bakers also work on Friday night. He added that she would be fired if she refused to comply with the company's policies. Under these circumstances, Mary likely does have a claim for religious discrimination because the bakery didn't even attempt to reasonably accommodate her. It might end up that it's not possible to accommodate her. Maybe there's only maybe 2 other bakers and there's just too much baking that has to be done on Saturday night for the remaining workers to do it. But in this case, the bakery didn't even attempt it, didn't even engage in that conversation. And that's a really bad fact. And so Peacock Bakery was foolish. It should have engaged in that conversation, should document it, and if it works out that it's not possible to accommodate, at least they will be in a better position to defend their decision. And of course, and hopefully, once they have the conversation, they'll be able to see that they can accommodate Mary's religious beliefs. And so that can be a win-win for the bakery and for Mary. Okay, let's talk about the next scenario. Mary has been an employee for 5 years. She works on the assembly line. And most of the people who work in Mary's area are bachelors, so males who are unmarried. Mary undergoes a religious conversion, and her new religion requires that she not work in close proximity to unmarried men. Because the duty to accommodate Mary's religious beliefs attaches to the conflict itself, not when the conflict arises, it is necessary for the employer to explore how to accommodate Mary. Now, obviously, the employer can't say, okay, you bachelors, you all need to get married, or they can't, require, this does present some challenges, and I'm not at all sure that the employer is going to be able to accommodate Mary, but at least there needs to be some discussion, some exploration of those issues. Maybe Mary can be in the same room with the unmarried men, but she can't, there may be some way of working it out. If there isn't, though, at least that the employer has engaged her in that conversation and explored those areas. And maybe there's another part of the facility that Mary would be more comfortable working in. Again, there needs to be that conversation to see if there is a possibility. And the bottom line is, the more difficult it seems to accommodate, the more important it is to have those conversations, to go to the effort of trying to solve the problem. And so definitely don't ever say, well, we can't solve this problem, so therefore we're not even going to have the conversation. That's setting yourself up as the employer for a lack of success. Aisha is a practicing Muslim and she is a member of the Army. She's requested to wear a particular headscarf with her uniform. Her request was denied because it does not satisfy the military dress regulations, which prohibit wearing any type of religious dress or symbols while in uniform. After she was denied this, unfortunately for Aisha, she's continued to wear this headscarf. And so she's been demoted. Aisha now has a complaint of religious discrimination. Unfortunately for Aisha, she's not likely to win because the reason that there is this rule barring soldiers from wearing religious symbols is that we don't want to associate a particular religion with the armed services. And that applies to everyone who wears the uniform. When they're in the uniform, they're not allowed to wear it. And so it's very unlikely that Aisha will be successful. But of course, the standard that we apply to the military is going to be very different than, the Domino's pizza delivery person or, the UPS delivery person. So don't assume that because the rules are a certain way for the Army, it's going to be the same type of rules for a private employer. In most cases, a private employer is not going to be able to prohibit an employee from wearing a headscarf. I've seen cases where private employers have been successful at, when there's safety issues about headscarves, maybe perhaps getting caught in machinery, and also when it obstructs the view of the employee, so the employee can't be as efficient in accomplishing the tasks. But if this is a headscarf that isn't impeding Aisha's view, and she's not in the military, most likely the employer is going to need to permit Aisha to wear the headscarf. Okay, let's go to the next here. So Bob's Pizza requires all of its employees to take an extra 10-minute prayer break per shift in a special room that contains a crucifix, which is a religious symbol for Christians. Mary's an atheist and she does not pray. She complains to the management because she thinks that these breaks are a waste of her time, sorry. And she would prefer to stay at her workstation instead of taking this 10-minute period of time off. After she complains, she is terminated. Under these circumstances, Bob's Pizza is liable for religious discrimination because it failed to accommodate Mary's conflict. Because, as we said before, atheism is considered a religion for Title VII purposes. I know that sounds like an oxymoron, but it is. I would think that probably the best solution for Bob's Pizza is to let Mary stay on the clock for those 10 minutes. If she obviously would be doing good pizzas, I guess, during that time. If for some reason Bob's Pizza doesn't want Mary to be on the clock for those 10 minutes, then I would suggest that they assign Mary someplace to meditate quietly that doesn't have a crucifix in it, or perhaps allow her to store the crucifix, or maybe there's some way to cover the crucifix while she is in having her 10-minute time of self-reflection or whatever. But certainly this was a silly path for Bob's Pizza to take, just inviting a lawsuit under these circumstances. So definitely don't want to fire somebody because they've request a reasonable accommodation. That's a foolish path for Bob's Pizza for sure. Okay, Bob is a mechanic and he's required to work 40 hours a week, including 2 Sundays per month. Bob tells his supervisor that he worships the National Football League and he cannot work any Sundays until after the Super Bowl. Anna Tyre can refrain from accommodating Bob's request as his beliefs are not sincerely held and they don't take the place of religion in his life. Obviously this is a silly one. This is one of the few cases where you literally can say, no, you don't mean that. It is not a religion for you. As much as people might joke around and say football's a religion, it really isn't. So let's go to the next one. Aditya is a devout Hindu and is a waiter and was a waiter at Frisco, was a waiter at Frisco restaurant. On a day when a banquet was held, he turned up at work with a religious symbol on his forehead. When confronted about this symbol by the manager, Aditya claimed that the symbol was a sign of good luck in Hinduism and that he had informed the management of his religious belief at the time of hiring. Unfortunately, the manager fired Aditya at that point. Under these circumstances, Aditya can show a prima facie case by establishing the practice of placing the symbol on his forehead is part of his religion. He can do that because he had already informed the restaurant about his religious conflict, and so he shouldn't have been disciplined for following his religious obligation. So under those circumstances, it was foolish to terminate Aditya. Now, if it were something, like, for example, white power or, something along those lines, there might have been something to reflect upon. But if it is an apparently innocuous symbol that isn't going to offend anybody else, then certainly the manager ought to allow Aditya to wear it and perhaps reflect more on it later on, or at a minimum not terminate him until there's been the opportunity to consider more carefully how this can be accommodated going forward. Next scenario. Salina Hospital has 20 Muslim employees in its maintenance department. The hospital has a designated room in the basement for its Muslim employees to follow their religious prayers that many of them participate in. Muhammad has refused to use this room in the basement because he feels it degrades his religion, because it's not in a place of respect in his estimation. So instead of using the designated room, he uses the visitor's waiting room on the 3rd floor to pray, despite the fact that his supervisor has asked him not to pray there. As a result of Muhammad's actions, he is terminated. Muhammad is not going to have a good claim here because he hasn't cooperated in his accommodation. He knew he wasn't supposed to do it there. As you can imagine, that's going to be disruptive of the visitors who are using that waiting room, and certainly not as helpful as it can be. Now, probably the hospital should have explored with Muhammad if there might be another room that would be more appropriate to do, but Muhammad on his own shouldn't engage in self-help and identify another place. He should not disobey the instructions of his supervisor. Okay, we're back to a Mary story. Mary is a deputy with the sheriff's office. Anti-abortion protesters have announced that they're going to hold rallies at some medical clinics where abortions are performed. The sheriff's department decides to assign officers to guard the clinics. Mary tells the chief of police that she has strong religious beliefs opposing abortion, and so she feels like she cannot guard these clinics. The chief tells Mary that she can patrol elsewhere during the rally. So that's the accommodation that the chief is offering Mary. So good, so far so good. Unfortunately, during one of the rallies, a riot breaks out in one of the clinics, and Mary is called as backup officer to assist. She refuses to respond to this emergency, and she's fired. Mary claims religious discrimination. Under these circumstances, though, the sheriff's department is going to win because in an emergency situation, a sheriff or deputy sheriff has to respond to do whatever needs to happen in that type of crisis situation. It would be an undue hardship to allow a sheriff who is scheduled to work to not respond to a crisis situation along those lines. So this accommodation was reasonable, but there's a limitation to how much accommodation can happen in a crisis situation. And it could be in another county that has a smaller number of deputies that this might not have even been reasonable. Let's say that there's only a handful of deputies, then it could be that this might not have been reasonable for counties of all sizes. Let's consider the next scenario. At the law firm of Juarez & Chu, it is the receptionist's job to coordinate a monthly birthday celebration, which includes ordering and picking up a cake, putting out birthday flyers, setting up the break room, and cleaning the break room after the party. Bob is the new receptionist, and he informs Ms. Chu that he cannot coordinate birthday celebrations because his religion does not believe in them. Very possibly, Bob is a Jehovah's Witness. Juarez & Chu can have Bob set up and clean the break room because that's ordinary part of lots of different meetings that Bob might prepare for or might as part of his job too. But probably the other parts of picking up and ordering the cake, putting up birthday flyers, setting up or not so much setting up, but these things probably can be handed off to another member of the team who might be willing to do so. And that would be a good solution. So Bob would have some of the tasks that he otherwise would be doing whenever the break room was being used for any purpose that is not specifically, birthday oriented. That would be a reasonable accommodation. Okay, Farmersville Steel Fabricators hires Mahinder, who's a practicing Sikh, as a forklift driver. Occupational safety regulations and company rules require all employees in the plant to wear a hard hat. It's for safety, and OSHA does not permit really any deviations from those rules. Mahinder refuses to wear the hard hat because he is unwilling to cover his turban. It may also be the case that there aren't any hard hats that will permit the wearer to have a turban on and then have a hard hat on top. The employer demotes him to another role that does not require that he wear a hard hat. Mahinder alleges discrimination based upon religion. The employer will win if a demotion was the only alternative available that did not cause an undue hardship. And very likely, again, because safety is an issue, that the employer is going to win. And as we said before, sometimes a demotion or a termination is the only way to accommodate those, but those should be kind of last choice options when the other options just aren't going to work and have been very thoroughly explored and documented. Okay, this is the big case. This is the big U.S. Supreme Court case about accommodation. We're really not going to focus on this, though, too much because this has to do with First Amendment issues versus Title VII issues. In this case, an employee was denied unemployment benefits because he was unable to continue working in a particular place that was involved in weapon manufacture. And so he wasn't able to continue there because of his religious beliefs. The state unemployment board wanted to not approve him for unemployment benefits because of alleged misconduct, because he was refusing to do his job. And the U.S. Supreme Court said no. He could be entitled because he engaged in no misconduct by following his religion. He could not be denied unemployment benefits because he was following his conscience. It's the important U.S. Supreme Court case in this area, but because it has to do with First Amendment issues more than Title VII, it has relatively limited applicability to our area. So as a result, you don't need to know the name of this case. Sometimes employees will say, well, I'd really like this solution instead of that solution. But the important issue is, do both solutions satisfy the religious accommodation needs of the employee? And if they both do, it doesn't matter that the employee would prefer A instead of B. The employer gets to choose between those options. And so let's consider this scenario. So Mary joins a particular church, and in this church, she's not allowed to wear pants. Her employer requires all employees to wear coveralls provided by the company for safety reasons. Although Mary wore the uniform prior to joining the church, she now refuses to wear the uniform. She complains to the owner, who saying pants is against her religious belief. Bob does make an exception in her case and allows her to wear knee-length boots with a protective jacket. So this is the accommodation. Mary refuses to wear the boots because they are unfashionable, not because they don't satisfy her religious objections, but because of another area, just a secular preference, style choice. Bob then fires her for insubordination. Under these circumstances, Bob isn't liable for religious discrimination because he did reasonably accommodate her religious beliefs. Mary doesn't get to pick between the option that Bob finally selects, as long as it fully does accommodate her religious beliefs. Okay, here we have Mary again. Mary has been a customer service associate with the department store for 10 years. Her job involves providing assistance to customers. Although she's been a Methodist was a Methodist at the time of her hire, she converts to Islam and reports to work wearing a hijab, which is a full-length cloak and with a small mesh-like screen to see through. Her employer tells her that wearing a hijab violates the company's dress code for a job profile and asks her to change her attire. Mary refuses to oblige. Her employer, after much deliberation, informs her she can continue to work in the customer service department and provide assistance over the telephone, a role that requires no face-to-face interaction with the customer. This role change is offered to her without any reduction in pay or other benefits. Under these circumstances, probably the department store is not going to be liable under Title VII because Mary was offered a reasonable accommodation that allowed her to retain her employment. I say probably, but I would recommend that Mary be allowed to continue to interact with customers face-to-face. I think that there's no real business reason why she would be unable to assist customers while she's wearing her hijab. I recognize that there could be customers who are uncomfortable or offended by that. Usually, though, customer preferences aren't a good way to address Title VII issues. It is true in this case that since Mary isn't receiving the diminishment in her pay and she's largely doing the same job responsibilities, that the department store might be able to successfully use this theory, but my opinion is that it's a bit of a risky one. So the accommodation doesn't have to be the one that the employee prefers or even the most reasonable one in every case. This is another U.S. Supreme Court case. Actually, this is a Title VII one. The question is, must an employer accept the employee's preferred accommodation absent proof of undue hardship? And the answer is no. I'm going to go through the facts here because this one's kind of an interesting one. It takes a little bit of work to get through the facts, though, so bear with me a bit as we think about these facts. So, well, Ronald here is a teacher with this school, and he's a member of a religion that requires its members to refrain from secular employment during specified holy days. And this is going to require Ron to miss 6 school days a year. This is a unionized facility, and Ron is only entitled to 3 days of annual leave a year for religious observances. So we've got to deal with the 3 days that aren't covered. He's not permitted to use up his sick leave days for religious observances. So he uses the 3 days that he gets under the union contract, and then he takes 3 unpaid days for the additional days to get up to 6. Despite his request, the Board of Education has repeatedly rejected his proposal that he be allowed to use 3 paid days of personal leave for the 3 days of leave here. So what he wants is he wants to use his 3 paid days for this instead of making them 3 unpaid days. And the school board has not allowed him to do that. The U.S. Supreme Court held that the employer had met its obligation under Title VII when it offered a reasonable accommodation. The court found no basis for requiring an employer to choose any particular reasonable accommodation. So again, while the employer could have allowed Ronald Philbrook to use his 3 paid days of personal leave, I guess this would be the sick days, it is not required to do so. Now again, I would take the position of why even get into this? If Ronald had the 3 days of personal leave available to him, why not allow him to use that in addition to his 3 paid religious holidays? It seems like you're fighting a battle and antagonizing an employee in a way that's not likely to end happily for anyone. But if an employer kind of wants to play a little bit of hardball, if the employer is willing to take some risk, then it may be something that is workable. Okay, so now we're going to flip and talk about the topic of undue hardship. As we said before, there's a line. The employer has to go up to the line, but doesn't have to cross the line. So reasonable accommodation is on this side of the line, and then this is when the line is undue hardship. Now, of course, these are such fact-specific inquiries. Where that line isn't always immediately obvious. And so since an employer isn't going to be at a disadvantage if it does a little bit more than is required, usually employers, to avoid that litigation, are going to be sure that they go at least up to the point and maybe even a little bit farther. So let's talk about undue hardship. Okay, so again, Title VII requires employers to accommodate an employee's religious beliefs up to the extent that it does not cause an undue hardship. We've already talked about the fact that the duty to reasonably accommodate only applies to religion and disability. There is no need to accommodate, the other categories that are covered by Title VII, such as gender or race or color or national origin, or age as covered by the Age Discrimination and Employment Act. Undue hardship is defined as the burden imposed on an employer by accommodating an employee's religious conflict that would be too onerous for the employer to bear. And as we've talked about before, we're talking really about a de minimis duty here, a much lower duty than we'll see with disability discrimination, disability accommodation requirements. The duty to reasonably accommodate an employee's legitimate business practices requires an employer to avoid conflict between workplace practices and the employee's religious practices or beliefs. We talked about that de minimis term. That's where it becomes an undue hardship. So here are some factors that could cause something that seemed like a reasonable accommodation to cross the line over into undue hardship. Again, the nature of the employer's workplace. Is it a 24/7 operation where important stuff is done, say, during the times where this employee might need to be off? Or is it an 8 to 5 type work scenario so that there's much easier to accommodate, say Friday afternoon hours or something along those lines? What is the type of job? If it's a type of job where people are largely fungible, where you can replace Bob with Sarah or Sally or Bob or Larry or whatever, or is your workforce really limited to just a few people who are skilled in that area, and you really need Bob to be there on that day to really address the issues that Bob knows about? As we talked about before, it's really a de minimis standard for the cost of the accommodation. Finally, how willing are other folks in the workplace to jump in and to assist in this accommodation? The employer doesn't have a lot of control over that. Certainly the employer should uh, attempt to motivate employees to be willing, but if the employees aren't willing, ultimately that's not going to be the employer's fault. Sometimes there are unions involved. Unions have an obligation to reasonably accommodate up until the point that it causes an undue hardship. But certainly when a union is involved, it does become a more complex situation. Now we have kind of three entities, the employer, the union, and the employee that all have to work together. And so that's an important part of that can certainly make this a more challenging, certainly a more time-consuming situation. And then, of course, you have to consider emergencies. When everything is going as expected, you may be able to work around that particular accommodation. But when, there's people sick from work, and there's nobody left that can cover that particular shift, or there's some kind of emergency and it's the fire department, and so therefore we need every hand on deck, sometimes those requirements are going to make the reasonable accommodation turn into an undue hardship. So let's consider a scenario here. This has been in the news lately. You may have heard about these situations. Bob's a pharmacist, and he's informed his manager during his job interview that he is unwilling to provide contraceptives because of his religious beliefs. The manager has agreed to accommodate Bob by relieving him of the duty of filling birth control prescriptions and taking orders for birth control drugs from customers or physicians. So this is the accommodation that the employer has arrived at. These tasks are assigned to other physicians, even though the physicians were reluctant to take on pharmacists, even though they were reluctant to take on the additional responsibilities. After the work started, Bob says, "I need some more accommodations." He's refusing to transfer phone calls from patients seeking contraceptive. He leaves them on hold indefinitely, and he walks away from people who ask about birth control drugs without notifying other staff members that somebody needs assistance. And so obviously this is negatively impacting the customer service level that this pharmacy is experiencing. The manager offers this alternative. The manager offers to relieve him of counter duty, but could not relieve him from telephone duty, as the high volume of calls mandated that all employees answer the phone. So the high volume is making it impossible to let him not do the telephone duty. Bob refuses to accept his role change. As a result, he's terminated. Under these circumstances, the manager can show undue hardship in requiring other employees to perform a disproportionate share of the workload. Now, if this were a pharmacy that, had 50 pharmacists or always had at least 5 people on staff on a particular time, the answer might be different. Of course, it depends upon how many calls. So you'd want to document all that stuff. You'd want to actually establish, well, how many calls do we receive on a standard shift? And how many people do we have working on that shift? And so you'd want to crunch some numbers before you said, no, we can't handle that. But in theory, if the numbers play out, then that would be certainly something that you could consider. You might want to consider transferring Bob to a busier pharmacy that has a higher staffing level, for example. An employer who discharges an employee for refusal to join a union because of his or her religious belief is in violation of Title VII. In Texas, we are a right-to-work state. We'll talk more about what that means when we get to the union material, but union security clauses are unlawful in Texas, and so you won't see employers terminating employees because the employee has refused to join the union. That's just not going to happen in Texas. But if you were to move to a different state, sometimes the rules are somewhat different, and depending upon the collective bargaining agreement, sometimes arrangements like that can be in effect. Employees with religious objections must be reasonably accommodated, including the possibility of an alternative of keeping their jobs without paying union dues. A union, however, can prove undue hardship if many of the employees choose to have their dues instead of paid to a non-union, non-sectarian charitable organization, since the impact of the union would not be insubstantial. Now, again, we are a right-to-work state, so a union can't require anyone to join it. And so this is more of an objection in other states. So let's pretend that we are, say, in the state of, we'll say, Wisconsin here. So Mary's religion prohibits her paying union dues. She has recently been hired as a truck driver by Plano Transportation in Wisconsin, strangely enough, where all the workers belong to a union. Any newly hired worker is required to join it within 90 days of accepting employment. This is called a union security clause, and as I said before, is unlawful in non-right-to-work states. Mary refuses to join the union and asks that the requirement be waived for her. The union refuses and requests that the employer terminate Mary. She will not be entitled to accommodation of her religious beliefs if the union can show an undue hardship by showing that Mary's request was part of a widespread refusal to pay union dues. Of course, the union will and the employer will be entitled, Mary will be successful if the union can't show that. And as I said before, in Texas, this really wouldn't even be an issue because the union would not be permitted to force the employer to fire Mary. This is another one of the turban cases. So we talked before about the turban, but let's talk about the actual case. This isn't a big case. This is just a district court from New York City. It has to do with the subway system there. So can an employee successfully complain of religious discrimination if equipment required for a job and mandated by the federal government safety regulations interferes with the employee's religious beliefs? And the answer is no. The employee is not going to be successful. So Khalsi is a member of the Sikh religion. He needs to wear a turban as part of his religious obligations, but because of the nature of his job, he's also required to wear a hard hat. Well, there aren't any hard hats that can be worn with his particular turban. Khalsi says, listen, if I hurt myself, if something falls on my head because I'm not wearing a turban, I can live with that. But that should be on me whether that happens. The employer says, well, no, not really, because if you're hurt at work, you're going to be entitled to workers' compensation benefits, which ultimately the employer pays for. Number one. Number two, if you're hurt at work, it may be necessary for your coworkers to rescue you, and they may be putting themselves in harm's way by doing so. So as a result, it's not really just your decision. We have the right to insist that you do these things. And so he was dismissed when he refused to wear the hard hat. And the court said, again, no, this is an undue hardship to require an employer to accept the risk that Khalsi might be injured. OSHA doesn't have an exception in this area, and so Khalsi needs to seek employment in a position that would not require the wearing of a hard hat. You don't need to know the name of this case, but you do need to know how the courts are going to handle these types of circumstances. Okay, so let's conclude here with the undue hardship information. Title VII makes it unlawful for an employer to make employment decisions that discriminate based upon religion. And unlike prohibitions against race and gender discrimination and national origin and color, there is no absolute prohibition under these circumstances. Courts are likely to find undue hardship if the employer must violate the seniority provision of a valid collective bargaining agreement, or if the employee has to pay out more than a very small cost to replace a worker who has religious conflicts. Again, disability discrimination cases are going to require significantly more expense in most cases. And also, usually employers can't be made to force other employees to trade shifts with the employee who has a religious conflict. Some employers do require employees to switch, and certainly an employer can do that. But if the employer chooses not to force the switches, most likely the employer is not going to be required to by the courts. This is the de minimis case, the Hardison case, a TWA versus Hardison. This case is important. You need to know its name, its holding, and it's significant to employment law. This is the case that established that de minimis standard and really took a lot of the wind out of the sails of the whole reasonable accommodation requirement under Title VII for religious observance. So here's the question. Does Title VII require an employer to accommodate the religious needs of its employees if doing so violates the terms of seniority rights protected under a collective bargaining agreement? And the answer was no, not so much. The particular employee was a machinist, and because of his religion, he had limitations on when he wanted to work. He wanted to work only 4 days a week. That would allow him to be able to maintain his religious obligations. But he didn't have enough seniority to bid into those jobs, so he wanted to jump ahead of other folks. Well, the court said no. Employer had a reasonable effort by making the accommodation, made a reasonable effort at trying to make an accommodation held in favor of TWA. This ruling is referred to as the de minimis burden of undue hardship. And it establishes the degrees to which employers must accommodate religious observance. And the bottom line is, it's not an overwhelmingly strong duty. Having said that, none of this means that an employer can't accommodate beyond the standard. It just means that the level that an employer has to do is relatively modest in the area of religious accommodation. So at this point, I'm going to end our second lecture, and we will continue on with the final topics in our third lecture. As always, I thank you for your participation and hope that you've enjoyed it. Again, if you have questions, feel free to send me an email. My email is cgroover@collin.edu. And even better, why don't you stop by and we can talk in more detail about the scenarios or any other questions that you might have. Thank you for your attention, and I hope you have a wonderful day.